Since freedom and liberty were two of the absolute benchmarks of the Constitution and of the founding of the United States, I want to talk a little bit about two aspects of that are very important. One of them is civil liberties, the other is civil rights. Be aware they are different. Civil liberties and civil rights are not the same thing. Civil liberties are basically the sort of fundamental principles that apply to everyone, that create certain rights for Americans. When you, as an individual, have the right to the internet, or have the right to view a movie, or listen to a radio, or things like that, that right comes from the civil liberties, the freedoms that are established in the Constitution. If you think about separation of church and state, for example, as well as the right of Americans to practice religion freely, those are fundamental liberties whether you're black, Asian, woman, man, regardless of your age. Let's start with a definition. Civil liberties. Civil liberties limit government action against individuals. It's what government cannot do. Most of the first important principles of civil liberties were put in the first 10 amendments of the Constitution, the Bill of Rights. The reason they were put in there rather than written right into the Constitution is that some of them were so controversial that the delegates of the convention in Philadelphia would have disagreed on a lot of these, and the Constitution probably would never have been actually written and ratified by the states, because some of these were pretty controversial issues. Remember, these things were done, these liberties were put in place because the founders did not really trust government very much. In other words, they are essentially protections for citizens against excessive governmental intrusion in people's lives. That's one of the curious things about the United States, and it's obvious in these civil liberties discussions. We are skeptical of our government. We know we need it. It does a lot of good things. We want to have a government that functions properly, but at the same time, we do not want a government that takes over our lives, that oppresses us, that is too narrow in terms of defining what is right and wrong, and therefore, on all kinds of issues, including protection from the police, we rely on our civil liberties. Now let's summarize some of the major points of this chapter. Originally, the Bill of Rights limited only the power of the national government, not that of the states. Gradually and selectively, however, the Supreme Court accepted the incorporation theory, under which no state can violate most provisions of the Bill of Rights. First Amendment protects against government interference with freedom of religion by requiring a separation of church and state under the Establishment Clause, and by guaranteeing the free exercise of religion. Controversial issues that arise under the Establishment Clause include aid to church-related schools, school prayer, teaching of evolution versus creationism, school vouchers, placement of religious displays on public property, and discrimination against religious speech. A couple of issues, concepts you'll need to know about. Lemon versus Kurtzman case. Courts ruled that government must avoid an excessive entanglement with religion. And court rulings on religion generally have struck down official prayers composed by school officials, but they've permitted moments of silence with a secular purpose. First Amendment protects against government interference with freedom of speech, which includes symbolic speech, such as flag burning. Supreme Court has been especially critical of government actions that impose prior restraint on expression. Other speech that does not receive First Amendment protection includes expression judged to be obscene or slanderous or libelous. And obscenity, the concept you need to know, to be obscene, for a work to be considered obscene, it must lack serious redeeming literary, artistic, political, or scientific merits. Other unprotected speech includes libel. Libel is defamation of character, reputation, business, or property rights in writing. Slander, the same thing, but that's done verbally. Statement must be made to or within the hearing of a person other than the defamed party. Under the Ninth Amendment, rights not specifically mentioned in the Constitution are not necessarily denied to the people. Among these unspecified rights protected by the courts is a right to privacy, which has been inferred from the First, Third, Fourth, Fifth, and Ninth Amendments. Whether an individual's privacy rights include a right to an abortion or a right to die continues to provoke controversy. We see some of the abortion right to privacy cases: Roe versus Wade, for your quiz purposes, Griswold versus Connecticut, landmark case, a Connecticut law banning contraceptives. The courts found that law violated a woman's right to privacy. Again, we see privacy rights with the right to die. Do privacy rights include the right of terminally ill people to end their lives through physician-assisted suicide? One of the more controversial issues taking place in California right now. The Constitution also includes a number of protections for the rights of persons accused of crimes. Under the Fourth Amendment, no one may be subject to an unreasonable search or seizure or be arrested except on probable cause. Under the Fifth Amendment, an accused person has the right to remain silent. Under the Sixth Amendment, an accused person must be informed of the reason for his or her arrest. The accused also has the right to adequate counsel, even if he or she cannot afford an attorney, and the right to a prompt arraignment and a speedy and public trial before an impartial jury selected from a cross-section of the community. In Miranda versus Arizona, Supreme Court held that criminal suspects, before interrogation by law enforcement personnel, must be informed of the right to remain silent and the right to be represented by counsel. Exclusionary rule forbids the admission in court of illegally obtained evidence. There is a good faith exception to the exclusionary rule. Evidence need not be thrown out owing to, for example, a clerical error in a database. On the death penalty, under the Eighth Amendment, cruel and unusual punishment is prohibited. Whether the death penalty is cruel and unusual punishment continues to be debated. In a case that may show up on your quiz, Gideon versus Wainwright, courts ruled that if one cannot afford an attorney, the government must provide one. Please use this lecture and your study guide to help you prepare for your quiz. Good luck.